As the online itinerant, I regularly hear about situations where a deaf or hard of hearing student is not getting the services, the accommodations, or the programming that they should be. In my mind, the alarm bells start going off, and I think to myself, oh my God, this is a lawsuit that is waiting to happen. Now, I know that these situations are not happening because schools don't care about their students. The problem is, students who have a hearing loss are unlike any other special education student out there. I'm going to share with you 3 court cases where the family sued the school and won. Stay to the end because I am going to add the court cases that I anticipate could happen any second. By the way, I am not a lawyer and this is not legal advice. If you're interested in this type of content, make sure you click like so that I know that this is something of interest to you and I can make more content around this topic. Case number 1, Perez versus Sturgis School District. Miguel Perez came into the school district in middle school. He had extreme language deprivation, and the school determined that he needed sign language to access his curriculum. So they were supposed to get him a sign language interpreter, but they couldn't find a sign language interpreter, so they hired an aide who was supposed to learn sign language. When he graduated, the parents learned that he actually didn't have any skills. He couldn't read, and yet he had been getting A's in all of his classes all along the way. The parents first sued under IDEA, saying that he did not get a free and appropriate education. The interpreter didn't actually know sign language well enough for him to be able to learn the content that he was in the classes for. But here's what happened next. The family continued on and actually sued the school under ADA, the American with Disabilities Act, for discrimination. So here's our key takeaway. Lack of communication access can actually become discrimination. The next court case is Tam versus Tustin School District. This case is interesting because this is a deaf student who was getting good grades in the mainstream setting, requested captioning, and the school denied captioning because her grades were really good. The court said that while she had been able to get the academic concepts, she was missing peer comments and the social conversations and all the other things that were happening around her because of her hearing loss. Even though she was doing well in her classes, she didn't have equal access to everything that was happening in the classroom, and the school district lost the case. Case number 3, SP versus Whittier School District. In this situation, a preschool student qualified for an IEP under speech and language and not under deaf and hard of hearing. The family sued because the global impact of her hearing loss was never tested nor identified. The court ruled that they don't know the impact of her hearing loss because they never assessed it properly. This is a perfect example of how a school looked at academic progress only and did not consider the full impact of her hearing loss. Those are 3 cases that we have seen in the courts that have been ruled against the schools. So we've got the student who didn't get a sign language interpreter when they should have. Then we have a student who didn't get captioning when they should have. Then we've got a student that wasn't even tested for DHH services, even though she had a known hearing loss. Those are 3 cases that we have seen already happen. Here are the cases that I'm personally waiting for. Case number 1, denying a student access to their cell phone, which can be used for captioning and texting in emergencies, because the school has a ban on cell phones. For a student who could benefit from captioning or texting in social settings or in the classroom, in a school that is not providing captioning in any other way, I see this as an incoming possible discrimination lawsuit. This is, again, an ADA issue. The next lawsuit that I'm personally waiting for is placement options. Schools tend to think that the least restrictive environment requires a student to stay in their neighborhood district. That is not the true interpretation of the law. And this is exactly why special factors exist when it comes to students with hearing loss. Students with hearing loss need to have access to their peers. They need to have role models and be able to communicate directly with their teachers. The law states that the IEP team must consider the child's language and communication needs. opportunities for direct communication with peers and professional personnel in the child's language and communication mode, academic level, and full range of needs, including opportunities for direct instruction in the child's language and communication mode. For deaf students, Congress specifically instructed teams to consider communication and language access first. What are their opportunities for direct communication with peers? The law says direct communication, not mediated communication. This distinction matters because Congress specifically referenced direct communication with peers and teachers. So while academic achievement is still part of the equation, Congress is clear that this is not the most important aspect of providing services and accommodations for this population of students. Their academic levels is just one consideration. These special factors do not automatically require a deaf school or a regional placement versus a mainstream placement, but they do require teams to ask questions like, does the student have direct communication access? Does the student have peers who can communicate directly with them? Does the student have language models? Does the student have opportunity to have instruction delivered directly to them? Do they have equal access? And if they don't, what do we need to change to be able to provide this access? These questions become imperative when discussing placement opportunities for our students. Another lawsuit that I am waiting to happen when schools say a student's grades are fine, therefore they don't require any special education services or IEP goals from a teacher of the deaf and hard of hearing. To qualify a student under deaf and hard of hearing, we need two things. We need to prove that they have a hearing loss, and then they need to have an adverse educational impact. Our education is not exclusive to our grades. Our educational impact happens all around us. Our peers, the gym, cafeteria, the teachers, our emotional development, to how we make sure that we've got access to our own education. All of that is the educational impact of hearing loss. This is a lawsuit waiting to happen. Congress is very clear. We have to look at access and the global impact of the hearing loss. Courts are increasingly asking, does the student have meaningful access? Does the student have meaningful communication? Does the student have meaningful opportunity? So what's your prediction for future lawsuits? Will it be surrounding captioning? Will it be surrounding interpreting? Will it be surrounding placement? Or will it be surrounding something else? Put your prediction in the comments below. And if you like this content and you want to learn more about how to meet the needs of students who are deaf or hard of hearing, make sure you watch another video on this channel and subscribe.